school lunch, apparently there was difficulty on the audio feed, so people who were... Oh, it's up there.
Okay.
You just need to grow each other. That's
Yeah, well,
nice, nice tall male bat.
He couldn't hear me very well either. I thought, I'm not going to do that.
No, I can hear you fine, but the people that listen elsewhere.
My judge. So you're not finding a PS5 yet?
No?
Why? Do you know what you're hiding? Oh, you're all going to be something.
Good afternoon, Lords. I'm going to continue with the other status argument for our Article 14 point. Having dealt with the Supreme Court decision in Gillam before lunch, I'm going to move on to the other ways that we say the EAT erred in law in its decision on other status, aside from the fact that the law in Gillam has now moved on and changed, and we say this court is bound to follow the Supreme Court judgment. The first one of those, the ways in which we say the other side is wrong to dispute other status, I can deal with very briefly, where the certification office suggests that foster carers cannot be an occupational status because it is said it is not an economic activity. If the certification officer was right, that argument, we submit, could be raised as against all caring professions, and quite simply we ask this court to reject that point. And we refer at this point to a recent EAT case, Scottish EAT, in the decision in Glasgow County Council against Johnston. And we do it for the reason, my lords, that in that case, the Scottish EAT had to consider the position of a kind of foster carer who said they had been employed under contracts in a way which took them out of the run-of-the-mill foster carers type of type of relationship, if I can put it like that. And the reason why I want to go to that, even though it's only EAT authority, is because the reasoning is rather persuasive in terms of working in the home and indeed caring. Please could I ask your lordships to go in your authorities bundles to page 1834, which falls within volume 3.
Yes.
At this part of Lord Somers' judgment, he's considering whether there are any factors about the provision of services to children that would preclude foster carers being employed under a contract of employment. And at paragraph 25, 6 lines down, Lord Somers says, there is nothing about the provision of services to children that precludes their provision under a contract of employment. Residential establishments employ staff to provide care to children, nor does the fact that services are provided in the home preclude the existence of a contract of employment. Many employees work at home. I acknowledge that the relationship between the child and foster carer is one of special delicacy and ought to mirror that between a parent and his or her own child, quotes the AT decision in our case. I accept that parents do not look after children because they're employed to do so, but the relationship under scrutiny in this case is the relationship between the council and the claimants. I do not accept there is a necessary repugnancy between a relationship of employment with the council and a caring relationship between a foster carer and a child. The degree of control the Connex Agreement gives the council over the relationship between a foster parent and a child suggests there is no exact analogy to the relationship between a parent and child. And that, we say, is relevant because there was no reason why provision of foster caring per se was not work. And the final sentence is particularly pertinent, we suggest, because there's no basis on relying on the provision of care per se for denying the existence of other status. Being a foster carer is an occupational classification, just as a judge's. The next argument to deal with is that relied on by the Secretary of State and accepted by the EAT, at least in part, that there was a requirement for the status to be a personal characteristic. And for your Lordship's reference, it's back to 136 of the EAT decision, although I don't need to take you there at this point in the argument. In our submission, that simple requirement, it must be a personal characteristic, is no longer good in law. And the most apt way to show the court this is to look to the guidance given in the RGM case, and I'm going to take you to where that was quoted by Lord Justice Leggett in the case of C. And if one goes to page 1976 in the authorities bundle, which is again volume 3, please. C involved limits on the child tax credit if there were more than 2 children in the family unit. And when looking at the issue of other status, at paragraph 62, if your Lordships have that.
Yes.
His Lordship said there, no clear or coherent test of what constitutes a status for the purpose of Article 14 has has emerged in the case law of the European Court of Human Rights. The term status has often been said by the court to refer to a personal characteristic, but differences of treatment based on grounds which are more a matter of choice or circumstance than personality have been held to fall within Article 14, such as an individual's country of residence, immigration status. In recent judgments, the European Court has tended to prefer the description identifiable characteristic, a phrase which assumes rather than provides a criteria for telling whether a ground of discrimination should be provided as other status. And then if we go down, please, to paragraph 65, the same tendency to take an increasingly generous view of what is capable of amounting to a relevant status has been followed in the UK Supreme Court. And then we have a whole list of types of status in the rest of the paragraph. Please could we move on to paragraph 66 on the next page. In RGM, Lord Walker depicted the grounds covered by Article 14 as falling within a series of concentric circles with those characteristics which are innate or most closely connected with an individual's personality at the core. He gave the examples of gender, sexual orientation, skin colour and congenital disability. The wider circle would include characteristics such as nationality, language, religion and politics, which are regarded as important to the development of an individual's personality and reflect important values protected by the Convention. Further out in the concentric circles are characteristics that are more concerned with what people do or what happens to them than with who they are, but which may still come within Article 14, homelessness being one of them. The corollary of this is that the more peripheral or debatable any suggested personal characteristic is, the less likely it's to become within the most sensitive area where discrimination is particularly difficult to justify, and makes the point that that approach was endorsed by Lord Wilson in the Matheson case. And then Lord Justice Leggett comes on to quote from Stott in the Supreme Court, where Lady Black, Baroness Hale and Lord Mance each discussed the issue of status. I don't need to go further to that. So we say, quite simply, the findings of the EAT that one needed to have a status that related back to those set out in Article 14 itself, or at least be a personal characteristic, not represent where the case law had got to, as is seen reflected, we submit, concisely in Lord Justice Leggett's judgment, encapsulating their recent Supreme Court judgments.
How far out do these concentric circles go? So personal is in the middle, but you move away from that.
Yes.
Where does it stop?
Well,
or maybe there's no answer to that.
I think where it probably stops is where the difference in treatment identifies purely the status, and without the difference in treatment, the status does not exist. And that's been referred to
that's
as
rather
the
theoretical for me. I'm not sure I understand what you mean.
Well, I'm about to come to, my lords, one of the bases which the Secretary of State says you don't fall within other status, which is the application of what's been called the independent existence condition, which means your status cannot be defined purely by the difference in treatment you complain of. So if I say, they always turn off the escalator when I get to the building, and I'm being discriminated against on grounds of the status of having the elevator being turned off whenever I get to the building, the answer to that could be, that can't fall within Article 14, because if you take away the discrimination, that status evaporates. It has no independent existence outside the difference.
Well, that means that it's huge in its range. I mean, the circles may become easier and easier to justify. But I mean, what about? Well, we're getting a long way, I suppose, from anything we have to decide in this case. But still, an employer takes against an employee for no particular reason, but it can be demonstrated clearly it's nothing to do with race or gender, but just a personality dislike or sort of thing that happens between people. That would clearly not be covered by Article 14. Your status was just being you.
I mean, if you could say everyone with blue eyes is treated in that way, then you've got something
Well, all
to
right,
hang
yes,
on
but
to. But if your status was, you know, Lord Justice Underhill is treated in this way by X because they always treat him in that way, and it becomes entirely circular, then you
Anyway.
may start falling into the trap I've just described. But, my lords, this isn't a novel point. Almost every judgment about this says the boundaries of other status are difficult to define. And I could spend 20 minutes taking you to different
no, I
places
agree.
where
It's
that's
very
said,
tempting because,
but
speaking
there-
for myself, I've never understood how Article 14 works. And it, as you say, almost every judgment makes it clear everyone else has the same difficulty. But you say
Luckily, we're not in that arena.
the sum of the established categories are so close to yours that you have no difficulty.
Exactly. And in one point I must take from Lady Black's judgment in Stott, I don't have a lot of time to spend on this, but she said in her judgment that assistance could be garnered from other cases where other status was found. Now, those cases must now include the finding in Gillam, where judges were regarded as having a relevant status despite their not having a contract. And that extract from the Stott judgment is actually set out in our EAT decision. I believe it will be page 124 for your lordship. For the paragraph 63 of the judgment of Lady Black in Stott is set out in an extract in paragraph 134, and 6 lines up from the bottom of that paragraph is a sentence that starts, however, that should not, of course, undermine the assistance that can be gained from reference to the listed grounds, taking with examples of other status derived from the case law. So we add Gillam in the Supreme Court to that list. My lord, the Secretary of State seeks to persuade your lordships that foster carers don't have an Article 14 other status, as their status, he says, is defined entirely by the alleged discrimination. Our response to that is, it certainly isn't. And a good way of testing whether that is the case with any particular status is, as I've said, by taking away the discrimination in question, would the status remain relevant, significant, or indeed exist at all? So suppose you took away the requirement to have a trade union made up wholly or mainly of workers with contracts in order to be listed by the CO. If that didn't exist, would there still be the status of foster carers without contracts? Our answer to that is, of course, because the significance of not having a contract has all sorts of consequences for foster carers. There are all kinds of rights they don't have. They can't take whistleblowing cases. They're certainly not employees. They can't bring unfair dismissal cases. Not having a contract may well mean they have no private law rights at the moment, as opposed to public law remedies. So for foster carers without contracts, it simply can't be said that the independent existence condition has any relevance.
Incidentally, you're using your category as foster carers without contracts.
Yes.
The status that is being discriminated against is people performing services for reward without contracts, or if you like, Article 11 employees without contracts. It's not specifically foster carers, is it?
Well, when we get to the Article 14 argument, my lord, and look at the analogous situations, we compare ourselves to others in like situations. And for the purpose of the comparative question, one of those comparisons is indeed foster carers with contracts.
Yes, of course. But sorry, I just wanted to be clear. For the purpose of your analysis, your status, although it may be a useful shorthand to say foster carers without contracts, the actual status is Article 11 employees without contracts.
The reason why I hesitate is because it might affect the justification arguments at a dip down the line if you were defined that broadly, my lord.
Well, I wonder, but I mean, surely in conventional discrimination cases, in deciding whether there is discrimination,
Yeah.
you look at all the people that share, and looking at whether you can justify it, whether it's indirect, all that
Yeah.
sort of stuff. You look at all the people who share a characteristic which leads to the discriminatory treatment or impact. And in this case, it would apply equally to, let us say, judges.
But
Might apply to GPs. I would open up a new can of worms.
But we are entitled, my lord, to define our other status as suits our particular circumstances.
Well, I'm not sure you are you?
If we are a group of foster carers without contract seeking to have our trade union listed, the matters that come up for consideration in whether any interference is justifiable or not will be, as can be seen in the case here, pertinent to our actual profession, as well as to trade union.
The profession could be, you say, foster carers with contracts, or perhaps slightly broader, carers with contracts, or caring professionals on a slightly broader.
Well, that's a very good point, my lord, because the two groups that we have selected for saying we are in an analogous position with, for our Article 14 argument, is one, foster carers with contracts, like the Johnston litigants we've just looked at in Scotland, and secondly, care workers working in residential children's homes. So,
suppose having a comparator that is relatively close to yours means that you can apply similar policy considerations on both sides of the equation.
and my lord, we'll see how that pans out when I get to that particular part of the argument, which I'm coming to shortly. Keeping an eye on time, my lords, can I just press on to take you to one other extract in the case of C, which dealt with the independent existence condition. It's paragraph 67 at 1977. And it's at little f, please, where Lord Mance, I'm sorry, Lord Justice Leggett.
Sorry, I just put it away.
Yes, it's volume 3, please, page 1977. At page.
Got it.
So at little f on the page, Lord Justice Leggett says it follows that status cannot be defined solely by the difference in treatment complained of. It must be possible to identify a ground for the difference in treatment in terms of a characteristic or classification, which is not merely a description of the difference in treatment itself. On the other hand, there seems no reason to impose a requirement that the status should exist independently in the sense of having social or legal importance for other purposes or in other contexts than the difference in treatment complained of. As Lord Mance put it, and this is in Stott in the Supreme Court, there is no difference why a person may not be identified as having a particular status when the or an aim is to discriminate against him in some respect on grounds of that status. And we take from that my lords, that here, being a foster carer without a contract cannot be said to be defined entirely by the difference in treatment. Not having a contract has all kinds of implications, aside from being refused listing should you choose to form a trade union. So we ask the court to be mindful of the
Sorry, can I just say, is that no more than saying you have your comparator, you hold up A and compare them with B? Some of the differences might relate to the status, for example, legal differences, but there might be other differences which have adverse effects which attach to the unprotected person, which are unrelated to statute. You're just comparing A with B to see what the differences are.
Well, we're not at the stage of comparing A with B, my lord. We're looking at other status itself. You're looking at, and I'm replying to what's said against us, do you have an independent existence separate from the difference in treatment, the discrimination that you're complaining about here? And we say quite simply, yes, we do. It's obvious that foster carers without contracts have a status, an occupational status, with implications that abound in other different areas.
Yeah.
Although, as Lord Mance has said, you don't have to show that it's a significant reason. So we remind the court of the generous meaning given to other status, as reflected in the Stott Supreme Court judgments, and ask you to find, both because of the impact of Gillam in the Supreme Court and in accordance with the other case law we've looked at, that we do indeed have another status. Moving on to whether we're in an analogous situation with other workers who are treated differently, those comparators are, as I've said, foster carers with contracts and those who care for children under contracts in residential homes. Can I just give you the reference in the EAT judgment where we made that submission? No need to turn it up. Paragraph 129, please. However, the EAT at no point dealt with our comparison with foster carers with contracts. And we say that was an error of law in itself, and if it had considered that comparator, it would have been bound to reach the view that the two groups were in analogous situations. And if one looks at paragraph 140, page 126 of your core bundles,
Which page, sorry, did you say?
I believe it's 126 in your
Yep.
core bundles.
Yep, 140, did you say? Yep.
Please. We can tell from that paragraph that the EAT are not thinking about foster carers with contracts at all, because at little e, they make the point that other care workers who work fixed hours and are not required by statute to care for to treat the cared for person as a member of their own family. So they only consider there our second comparator, that is care workers in residential.
You had made the comparison with foster carers with contracts, this I see at 129C. At that point, you didn't have Glasgow as an example.
We had it in first instance, actually.
Oh, right.
Yeah. It hadn't got to the EAT yet. So the points which arise from that is that foster carers work under a regulatory regime does not, in our submission, prevent an analogous situation from arising. Indeed, in the Johnston EAT decision, the EAT judge said that Mr. and Mrs. Johnson worked under the same regulatory regime as the foster carers who didn't have contracts made no difference. The regime was identical in terms of statutory provisions. It was just that in the Johnston's case, there was an actual contract between the two parties. So the fact of the regulatory regime doesn't prevent the analogous situation arising. And the second point is to say that we and our comparators are not in an analogous situation is, we submit, to confuse the difference in treatment with the grounds for the treatment. And that was also suggested to the Supreme Court in Gillam, and Lady Hale said there in terms it was wrong to do so. And we see that at page 2116, which again is bundle 3. Paragraph 31, please. And she says there, no answer to say that by definition judicial office holders are not in an analogous situation to employees and LIMB workers. That is to confuse the difference in treatment with the ground or reason for it. What matters is the judicial office holder has been treated less favourably than others in relation to the exercise or enjoyment of the convention right in question. She is not as well protected in the exercise of that right as are others who wish to exercise it. And we say exactly the same applies here, and that suggestion that we're not in an analogous situation, as made by the Secretary of State, merely confuses reason for treatment with the difference itself. The treatment is not having a contract or not, it's the deprivation of rights. It doesn't matter for these purposes that comparators are not in identical or the same material circumstances. And that's because the comparative exercise here is not the same as one approaches under our domestic statutes such as the Equality Act, where you need to show that your comparator is a no material difference comparator. Here you're looking at how is the similarity between the disparate situations arising. Now, the Secretary of State relies on an old case called Van de Mossel about a Brussels pupil barrister who, horror forbid, had to do pro bono work. Indeed, was compelled to do it, and argued his Article 14 rights were infringed because of that. Didn't go down very well with the Brussels judiciary.
Wasn't there also a suggestion of slavery or involuntary servitude?
Exactly. UK pupils would never make that kind of argument. But he failed in his analogous situation arguments because the respondents in that case put forward all kinds of examples of people such as government workers, people who had different conditions for entry to the profession, the nature of the benefit pupils got from doing pro bono work in the long run, a whole host of factual distinctions, which led the European Court of Human Rights to say the evidence before the court doesn't disclose any similarity between the disparate situations in question. I don't have time or need to take you to that decision in any more detail, but it's fact-specific and it doesn't assist the Secretary of State here.
Remind me what the name of the case is, then.
Van de Mossel.
Van de Mossel, of course, yeah, I've got it.
Yeah, and just for your reference, my lords, Authorities Bundle 2455 to 6.
Thank you.
Volume 4. The last point we make on analogous situations is with regard to a care worker in a children's home. There's no reason, we submit, why working in a residential home as opposed to one's own home is relevant to the question of forming a trade union. That's what one has to focus on. And as we've said, It doesn't have to be similar in all respects, like an Equality Act comparator, just in a relevantly similar situation for the purpose of the treatment complained of. Moving on, my lords, to the question of less favourable treatment. Although the EAT made no specific finding on less favourable treatment, we say they ought to have made a finding that that existed. Can I refer you simply to our amended skeleton for this? It's paragraph 47 at core bundle page 56. I don't need to turn that up now. I need to move on. I come next to the correct test to be applied when looking at the question of justification for Article 11 read with Article 14. And I take you first to what the test was as applied by the EAT at paragraph 41, or page 126, please. At paragraph 141, they quote the Court of Appeal in Gilham, identifying the wide margin of appreciation, and then say at 142 on the next page, they're going to apply the manifestly without reasonable foundation test. When the case got to the Court of Appeal, Lady Hale said, in cases involving social or employment policy, the manifestly without reasonable foundation test is not always applied. My lords, can I just give you the reference for where she said that? It's paragraph 34 of the judgment, Authorities Bundle A1226-7.
What's the paragraph?
34.
I know you're in a hurry, but I think we ought just to look at
Of course, 1226.
Did you mean 1226?
Sorry,
1126, didn't
2116. Do beg your pardon. Paragraph 33 is the argument put forward by the respondent, which is almost identical, my lords, to what the EAT found in our appeal that we've just looked at. They say, allow a broad margin of discretion, 2 reasons, social policy, and because status in question isn't a particularly suspect ground. And Lady Hale says, no. The first problem with the argument is and I paraphrase, the manifestly without reasonable foundation. All the cases where that's been applied relate to welfare benefit systems. And she goes on to say at the bottom of paragraph 34, over on page 2117, this case is not in that category, but rather in the category of social or employment policy where the courts have not always applied that test.
Yes, but that's qualified by what she goes on to say in the first sentence of the next paragraph.
It talks about deference to the considered opinion of the elected decision maker, and then addresses the specific statute in question and excluded groups, and then the point in the next paragraph specific to Gilham that no legitimate aim had ever been put forward. My lords, what we say about the correct test to be applied is actually very simple. We say this case does not involve welfare benefits, socio-economic policy, or the allocation of resources, but focuses on the differential impact of the exclusion of trade union rights within the ambit of Article 11. In terms of the appropriate level of scrutiny that the court should apply, we don't ask the court to raise that level as one would do for a core status kind of discrimination, such as sex or race, but we also say don't lower it as you would do for a welfare benefits case. Rather, this is the ordinary application of the fair balance test. We agree that appropriate deference to Parliament decision making can take place, but it doesn't necessarily involve a significant measure of latitude in these circumstances. My Lords, I'm not going to spend time on why the margin of appreciation as applied by the Strasbourg courts should not be mirrored identically in our domestic courts. There's an awful lot of law on that, why the two tests, why that test shouldn't be simply transferred to our courts. It's a different kind of deference when you get to the domestic court. So while Strasbourg might give to the UK a margin of appreciation because member states organise industrial relations in different ways, the domestic court knows how the UK organises its industrial relations and is in a position to scrutinise that. Although we say here deference to the legislature shouldn't be particularly broad because the case doesn't involve allocation of resources or welfare benefits. Now, we've said in our skeleton argument that the manifestly without reasonable foundation test doesn't apply to the fourth fair balance element of the proportionality test. We should refer you to the recent reasoning by Lord Justice Higginbottom in the Joint Council for the Welfare of Immigrants decision, because his lordship put forward a rather more nuanced approach to how that scrutiny is examined, which we say is useful for looking at how to apply the test of justification here. My Lord, if you could go to that JCWI decision, at authorities bundle, it's again bundle, actually no, it's just in volume 3 please, page 2341. Paragraph 36.
136.
Yes, sorry, 136. On page 2341, his lordship said, although, as I've described, some authorities focused on whether that test applied or not, I don't regard this as a simple binary question. And then if you go down to 140, please. I'm just trying to identify the key parts of the paragraphs here. On 2343 at 130, 140, which is halfway down the paragraph, he starts, the greater the element of economic or social policy involved, the greater the margin of judgment and the greater the deference that should be afforded. That's, for obvious reasons, particularly so when the body is Parliament. However, if the measure involves adverse discriminatory effects, that will reduce the margin of judgment and thus the degree of deference, particularly so for a core attribute. That, in my respectful view, explains Baroness Hale's observation in Humphreys. If that analysis is right, whether seen in terms of the application of the MWRF criteria or simply in terms of the usual balancing exercise inherent in the assessment of proportionality, the result should be the same. So it's not an all or nothing binary question, says Lord Justice Higginbottom. And we submit that that is a useful way of looking at how to apply the test here. And it is borne out with how I've submitted you should apply that test here. You don't raise it because these aren't core suspect characteristics, and you don't lower it because there aren't allocation of resources or welfare benefits here, which would be particularly for preserve of Parliament. So can I move on to the balancing exercise in question and say here, looking at foster carers with contracts and care workers in children's homes, when saying that both those categories can form trade unions and indeed be listed, how can excluding us, the foster carers without contracts, be a proportionate means of achieving a legitimate aim? Indeed, the illegitimate aims relied upon for the Article 11 purposes fall away given the comparator, who is the foster carer with a contract.
What about the foster carer without a contract who enters a general union? And if they can benefit from being in a broader union, what's the justification for denying the right to those in a specialist union?
Well, it's said that the question is, if you're in a non-specialist trade union.
Well, I understand what they say. I'm
Yeah.
just wondering, if you can do it in one, why shouldn't you be able to do it in the other?
You mean, why can't it be done in the...
Yes, well, it undermines the justification. There's something particular about being a foster carer without contracts. If you can go into a general union and get that right, but you can't do it in a specialist union that might or might not protect your rights better.
Well, that's why the wording wholly or mainly in section 1 of Tulka undermines the justification in itself. If you're allowed to do it as a minority member, why should you be barred from having your specialist?
And that's the distinguishing factor. You're not in the majority.
But you know, so what? You say?
Well, that's your point.
Well,
So-
the point I put to you just before lunch, which my Lord has just put more elegantly, is actually two-edged. Well, they could join the GMB.
Yes.
You say, well, you don't accept that satisfactory, but if the justification arguments are so strong, applied to foster carers without thinking about whether they work under a contract or not, it's kind of odd that they can achieve collective bargaining rights as minority members of a general union, but not as members of a specialist.
Well, my lord, kind of odd, and also justification is not made out. So the last points to make about why the justification defence fails at this stage of the argument is in terms of whether any deference should be given to the choices that Parliament's made when examining who's in and who's out in terms of rights in the 1992 Act. We know that Parliament has excluded and included other occupational groups within the Act. Some without contracts have been specifically included. For example, healthcare professionals in section 279, for your Lordship's reference, Authorities Bundle, page 216. And there's a whole host of other categories there which we invite you to look over. And secondly, if it's said, well, we've considered whether to change the status of foster carers when undertaking the various reviews, we come back to the point that those considerations are not raised in the trade union context at all, but rather, if at all, for working time purposes. So the existence of the Tulka statutory scheme provides no rational or justifiable reason for treating our comparators differently from foster contracts. We say objective justification is not made out regardless of which test you use, even if manifestly without reasonable foundation is the correct test. There is no legitimate aim for our comparators, and the distinction is manifestly without reasonable foundation and fails the proportionality test. So the fourth ground of our appeal is that the EAT erred paragraphs 148 to 149 in deciding it would not be possible to read down section 269 to avoid a breach of Article 11 and or Article 14. And our submission is it's necessary and possible to do so without going against the grain or essential thrust of the legislation. Firstly, we rely on the reading down exercise carried out by the Supreme Court in Gillam, at paragraphs 42 to 43. And before I take you there, can I remind you that when deciding not to read down, the EAT in our case relied almost entirely on Gillam in the Court of Appeal in deciding not to do so.
Well, I thought in the Court of Appeal we said if it had been necessary, we thought we could have.
Well,
Doesn't matter.
my lord, that obiter comment, which was, of course, relied on by the Supreme Court in Gillam, and indeed by us below, to no avail, wasn't constantly persuasive by the EAT, but largely on the basis that it was obiter. But the point that Lady Hale makes at page 211B, please, in the authorities bundle.
You can't mean that. 211.
2119.
Yes.
It's So let's start at para 42, just above that page, 2118. The respondent argues that to do so would cut across a fundamental feature or go against the grain of the 1996 Act, but it is hard to see why that should be so. To interpret section 233B so as to include judicial office holders would not afford them all the rights afforded to workers under the 96 Act, but only those rights afforded to Limb B workers, most of which are inapplicable to judges. But in any event, the interpretation in this case would only relate to an exclusion which is incompatible with convention rights. Otherwise, the Section 3 duty doesn't apply. And she refers to her Lordship's decision or comment below and says she agrees and says it wouldn't be difficult, paragraph 40, to include within Limb B an individual who was an office holder. And then she talks about the grain of the legislation in the rest of 43 and decides in paragraph 44 that the provision in question can be read down. Now we rely on the similarity of those two provisions, section 230 of the ERA in issue in Gillam and 269 of Tulka here. And we respectfully submit that this court is bound by paragraph 42 of the Supreme Court in Gillam. But let's just focus on what is the grain of the 1992 Act. How does the case of Gaydon help us with this question? We say in our skeleton argument at paragraph 56, core bundle page 59, the grain here is the ability to form a trade union as long as it's made up of workers. The requirement for a contract is not a fundamental feature of the scheme, since extended categories do exist and foster carers are not specifically excluded, such as armed services are, and no evidence has been put forward of their considered exclusion in 1992. And we follow that up by saying it is workers who trade union rights are designed to protect. And the fundamental objective of regulating relationships between people is not disturbed by permitting workers without contracts, but who do have employment relationships, to have access to the scheme by being listed. We emphasise what matters most is the substance, not the form of the working relationship, and the concept of the employment relationship allows an analysis of key characteristics of someone who works for another, as we've looked at earlier this morning. And interestingly, in the Guyden case, looking at the survivorship of tenancies under the Rent Act, what the House of Lords focused on there was the essential equality of the relationship. The essential quality of the relationship, not whether it was heterosexual or homosexual. And we say here too, a purposive approach to Section 3 looks at the substance of the working relationship and beyond its label, beyond whether there's a contract or not. And of course, we are seeking to read down Section 269 for a specific and limited purpose. And we made that clear to the EAT at paragraph 121. Disappointingly, although they noted that, they didn't seem to apply it in the way they reached their decision. And I'll show you very briefly why that is. Paragraph 121 at core bundle, page 118. So firstly, at 121, the court notes that Mr. Hendy has made the point that reading down applies only for listing, and they say this is probably right, but the arguments made about perception of looked after children still hold good. And the error in particular there is not identifying how those perceptions are relevant to listing, as opposed to, if anything, more general and across the board. And then could I ask your lordships to turn to page 128 of the core bundle, paragraph 148. At the bottom of that page, they say, accordingly, we cannot accept Ms. Krasna's contention that her proposed reading of section 269 would not go against the grain of the legislation. In our view, to interpret the legislation so as to include non-contractual relationships within its scope would go against the grain. But the vital point missing, my lords, from that final sentence is within its scope for section 2 purposes. Because the way one reads that, it reads as though the legislation is being interpreted in each and every place that the definition of worker arises. And as we emphasised time and time again to the EAT, what we were seeking to read down for was a far, far more limited basis.
I'm not certain I follow that in the context of what now seems to be common ground, that a non-contractual foster carer can obtain precisely those rights if they join a general union.
I believe it will be said, my lords, that collective bargaining the machinery doesn't apply to them in the same way as it would apply to those with contracts, despite what the EAT found here at paragraph 91. But I'll leave that for those on the other side to develop.
my lord, should I just indicate that it's not common ground that the position of both the CO and, as I understand it, the Secretary of State is that all of the substantive rights depend on the definition of worker. So they're conferred on workers. So if you're not a worker, then even if you're a member of a general trade union, that union can't seek recognition in respect of you, can't accompany you to disciplinary meetings, can't call strike action.
I think
you.
put
But
down your
we'll
marker.
develop the
I
point.
develop it in
That's-
when we get to your submissions.
So we say, when looking at reading down here, the EAT simply didn't focus on the purpose for why we were saying reading down was necessary, or indeed what the grain of the legislation was. They simply said the demarcation adopted by Parliament between working under a contract and not was a fundamental feature of the legislation. And I'm afraid all the points that we made and put before the court were not taken into account, and we ask you to do that now. And I should also add points made by the IWGB in its skeleton argument as to why reading down should happen, and what a fundamental feature of the 1992 Act is. We rely on those submissions as well. Could I give you the reference for those? Core Bundle 219, paras 53 to 54. Last point to make on reading down. Both the Secretary of State and Certification Officer have urged the Court of Appeal to defer to Parliament when considering the Section 3 remit. We say that's not part of the exercise here. The Court will have already deferred at the justification stage. There's no requirement to do that a second time. Very last point in terms of wording for reading down. That's not an issue in this appeal. Both the EAT suggested alternative wording to that which we had put forward, and also we know it's not essential to identify a form of word. So potential amendment's not an issue, and we don't need to trouble any further with that.
Where is the EAT's? Where is
Yes,
the
of
EAT
course,
suggested wording?
It's paragraph 147. Oh, I'm sorry, 146. Your Lordship's page 138 of the core bundle, I believe.
Just give me a moment.
My submission had been the paragraph before, my Lord.
I mean, you either, there's the overriding point which you've already referred to, you don't actually have to submit an alternative draft. But if you were going to do that exercise, your submissions would be more accurately encapsulated by including in either formula, wouldn't it, something that made clear that the section 296, the definition in section 296, when applied in the context of, well, at least section 2 of the section 2.
Absolutely. My Lords, may I just check with my junior? There's nothing further that she wishes to forward. Thank you very much for your time, my Lords. Unless I can help you any further, though.
No, you've been extremely helpful so far. Thank you so much, Ms. Krasnow. Just give me one moment. Now, do you have to play a bit of shuffle with Lord Henry?
We will shuffle. Can we do that whilst your Lordships are seated, or would you like to?
Oh, no, of course you can. Yes, no, that's very... showing appropriate deference. A junior to do the heavy lifting, Lord Henry.
Not a good idea.
Do it in 2 bits. We won't mind. I'm sorry, you have got a junior, but you're very correctly not requiring her to do it.
Apologies, my lord.
No, take your time. And mind that your seating arrangement respects social distancing from Miss Newton.
Lords, our submissions are effectively a supplement to those of my learned friend Miss Krasnow, and I hope to avoid traversing any ground that she's covered, but there is just one point which I'd like to elaborate a little more, but I'll come to that in due course. Lords, at the very outset, your lordships will observe, of course, that the case is focused on the certification officer's refusal to list the NUPFC as a union and the consequences of not listing it. But it's worth noting in our respectful submission that the basis of the certification officer's decision is not just that the union is not on the list of trade unions maintained by him and cannot, for example, obtain a certificate of independence. If the CO is correct, then the NUPFC is not a trade union at all. And that's because trade unions have no status in law except by virtue of the legislation which is now contained in the Trade Union Labour Relations Consolidation Act of 1992. So that prima facie, and of course I don't for a moment suggest that it's as simple as this, but prima facie, it looks as if this might be a direct violation of Article 11, which guarantees the right to join and form a trade union for the protection of his interests as an express part of Article 11(1).
Isn't this just?
I'm sorry.
This is just a matter of labelling. It won't be a trade union within the meaning of the Act, if you're right, which I dare say you are about to show us. But it doesn't mean it won't be a trade union for the purpose of Article 11, or it can't describe itself as a trade union.
It would be curious, my lord, if Article 11, in allowing workers everywhere in Europe to form trade unions, found that in Britain workers could form an entity which was not classed as a trade union in English law.
Oh, I see that, but sorry, but that's I'm just that's where it cross purposes, or I haven't understood your point. But this is no more than another way of putting your main point, isn't it?
Well, of course, I just make it at the very outset. It doesn't resolve the issue in any way at all, but it is a significant point. And the reason that I make it is that Section 1 of the Act, which your lordships looked at the outset of my learned friend's submissions, but I just invite you to look at the words again. It's in Divider 2 of the Authorities Bundle in Volume 1, and I've got it at page 36 in the repaginated bundle, but I think it might be in page 152 of the bundle that my Lord Justice Underhill has.
Yes, thank you.
And the significant words for these purposes are meaning of trade union in this Act. A trade union means an organisation, blah, 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 wholly and mainly of workers, regulation of relations, and so on. So throughout the Act, wherever trade union is mentioned, it means a trade union in accordance with Section 1. So all rights which are trade union rights in one way or another are premised on the entity being a trade union. And that means that every trade union right is effectively denied to the NUPFC and its members, irrespective of whether it were listed or certified. Now, Lords, a learned friend has left me with a task of dealing with Article 11 a little bit more fully than she has. And what I propose to do, if it's convenient to your Lordships, is to look at some 5 cases in the European Court to establish certain principles and then apply those to the situation before your Lordship. All those cases are in the 4th volume of the Authorities. And I begin with a case of Wilson and Palmer in the United Kingdom. I'm very conscious, my Lords, that I laboured this and one of the other cases before my Lords, Lord Justice Underhill and Lord Justice Bean only last week, so that they may be very familiar with the passages.
Don't worry, I'm looking forward to this.
I'm very grateful, my Lord. I shall address
Well worth repeating.
So, my Lord, this is Wilson and Palmer is tab 80, which is page 2563. My Lords, the essential facts in Wilson and Palmer were that 2 workers in completely different sectors of industry were not given a wage rise which had been offered to all the workers if they had agreed to give up being represented by their union, which was formally recognised by the employer and which the employer intended to recognise. And the question was whether this was a breach of Article 11, and it was. And Lords, I take your Lordships to paragraphs 44 to 46 in the judgment, which is at page 2570. And in 44, the court considers collective bargaining. It says compulsory collective bargaining would impose on employers an obligation to conduct negotiations with the unions. Court has not yet been prepared to hold that the freedom of a union to make its voice heard extends to imposing on an employer an obligation to recognise a union. Union and its members must, however, be free in one way or another to seek to persuade the employer to listen to what it has to say on behalf of its members. And then that paragraph concludes by noting a wide margin of appreciation as to how trade union freedom may be secured. In 45, the court observes there were other measures available to the applicant unions by which they could further their members' interests. In particular, domestic law conferred protection on a trade union which called for or supported strike action in contemplation or furtherance of a trade dispute. The grant of a right to strike, while it may be subject to regulation, represents one of the most important of the means by which the state may secure a trade union's freedom to protect its members' occupational interests. And I invite your Lordships to highlight that. And at 46, the court agrees with the government the essence of a voluntary system of collective bargaining is that it must be possible for a trade union which is not recognised by an employer to take steps including, if necessary, organising industrial action with a view to persuading the employer to enter into collective bargaining with it on those issues which the union believes are important for its members' interests. Furthermore, of the essence of the right to join a trade union, the protection of their interests, employees should be free to instruct or permit the union to make representations to their employer or to take action in support of their interests on their behalf. If workers are prevented from so doing, their freedom to belong to a trade union for the protection of their interests becomes illusory. It's the role of the state to ensure that trade union members are not prevented or restrained from using their union to represent them in attempts to regulate their relations with their employers. So, my lords, we say these are strong burdens on the state to ensure that workers enjoy the benefits of the last few words of Article 11.1. Well, that's the first case. The second case is Daymir and Beykara and Turkey, which your lordships have at tab 88 of the same volume, at page 2738. Daymir and Turkey was a case in which a local government union reached a collective agreement with a local government body, a collective agreement, and that was overruled by the courts on the basis that local government officers had no business, no right to negotiate collective agreements. Daymir and Beykara, of course, is a very important case in this area of the law because it established for the first time that the right to bargain collectively was an essential element of Article 11. Lords, I take your lordships to paragraph 145 at 2752. In paragraph 145, the Grand Chamber sets out some existing essential elements of the right of association, the right to form and join a trade union, prohibition of closed shop agreements, and the right of a union to seek to persuade the employer to hear what it has to say on behalf of its members. And then at 146, list is not finite. On the contrary, it's subject to evolution, depending on particular developments in labour relations. In this connection, appropriate to remember that the Convention is a living instrument, must be interpreted in the light of present-day conditions, in accordance with developments in international law, so as to reflect the increasingly high standard being required in the area of protection of human rights, thus necessitating greater firmness in assessing breaches of the fundamental values of democratic societies. In other words, limitations to rights must be construed restrictively in a manner which gives practical and effective protection to human rights. So, as a general proposition, restrictions to be construed restrictively. And then at 154, having reviewed the evolution of the right to bargain collectively in international law, the Grand Chamber says, 154, consequently, Court considers that having regard to developments in labour law, both international and national, and to the practice of contracting states in such matters, the right to bargain collectively with the employer has in principle become one of the essential elements of the right to form and join trade unions for the protection of one's interests set forth in Article 11, it being understood that states remain free to organise their system so as, if appropriate, to grant special status to representative trade unions, like other workers, and it deals with the civil service, which was at issue in that case. So the importance of collective bargaining is stressed by that case. Well, the third case in the series is the next one in the volume, tab 89, Danilenkov and Russia. Well, this case concerned a strike of a dockers union in a particular port in Russia. The strike lasted for 2 weeks, and as a consequence, the employer penalised those who had taken strike action by denying them overtime, putting them at the top of the list for redundancy, and so forth. Well, the material passages to which I would wish to draw attention are at paragraph 123, which is at page 2780. I should say that in this case it was contrary to criminal law to discriminate against unions in the way that the employer had, but the European Court held that that was not enough, At 123, they say, nevertheless, as to the substance of the right of association enshrined in Article 11, Court takes into consideration the totality of the measures taken by the state concerned in order to secure trade union freedom, subject to its margin of appreciation. An employee or worker should be free to join or not join a trade union without being sanctioned or subject to disincentives. The wording of Article 11 explicitly refers to the right of everybody, and this provision obviously includes a right not to be discriminated against for choosing to avail oneself of the right to be protected by a trade union. Given also that Article 14 forms an integral part of each of the articles laying down rights and freedoms, whatever their nature, thus the totality of the measures implemented to safeguard the guarantees of Article 11 should include protection against discrimination on the ground of trade union membership, which, according to the Freedom of Association Committee of the ILO, constitutes one of the most serious violations of freedom of association, capable of jeopardising the very existence of a trade union. The Court finds crucially important that individuals affected by discriminatory treatment should be provided with an opportunity to challenge it and should have the right to take legal action to obtain damages and other relief. Therefore, states are required under Articles 8, 11 and 14 to set up a judicial system that ensures real and effective protection against anti-union discrimination. The Court thus has to consider whether sufficient measures were taken by the authorities against the discriminatory treatment. Well, the fourth case is one has to go back to tab 82. This is Tum Harbour Sen in Turkey, which was referred to in Damir and Turkey. It's at page 2604. And I just read head note 1. Applicants were a trade union and its former president, union formed by public sector employees. Shortly afterwards, Governor's Office sought the suspension of its activities and dissolution on the ground that state employees couldn't form trade unions. District Court suspended the trade union activities on appeal. Judgment quashed, referred the case back to the district's court, and so on. The case came to the European Court of Human Rights, and I draw attention to paragraphs 35 to 36, which are at page 2613. Here the court is dealing with the question of whether there'd been an interference, and in particular whether the interference was justified. Lords, if I pick up paragraph 35 halfway through, there's a line beginning with the word justify restrictions, and the sentence beginning on that line is, in determining whether a necessity within the meaning of Article 11.2 exists, the contracting states have only a limited margin of appreciation, which goes hand in hand with rigorous European supervision, embracing both the law and the decisions applying it, including those given by independent courts. In the instant case, the government's arguments provide no explanation as to how the absolute prohibition on forming trade unions imposed on civil servants and public sector contract workers in the communications field by Turkish law, as applied at the time, met a pressing social need. The mere fact that the legislation didn't provide for such a possibility is not sufficient to warrant a measure as radical as the dissolution of a trade union. And at the bottom of the page, paragraph 40, the same point is made in a different way. Accordingly, in the absence of any concrete evidence to show that the founding or the activities of Tum Harbour Sen represented a threat to Turkish society or the Turkish state, the court is unable to accept that an argument based solely on an absolute statutory provision was sufficient to ensure that the trade union's dissolution complied with the conditions in which freedom of association may be restricted. In view of clear legislative provisions on the subject, and I don't need more from that paragraph. Lords, there's one more case that I wanted to refer to in detail, but before that, may I just draw your lordship's attention to a series of cases to which I don't propose to go now. Entitlement to form an entity recognised by the state is clearly an aspect of Article 11. And in a series of cases not dealing with trade unions, the court has found that the refusal of the state to recognise such an entity by registering it or listing it or in some other way is a breach of Article 11. Now, except in these other cases, different consequences followed from non-registration or non-listing. But nevertheless, the cases taken together shows the importance under Article 11 of a statutory recognition of entities which citizens wish to form. The cases are, my lord, they are referred to in our skeleton argument, but they are Gorzelik and Poland, which is at tab 81, Moscow Salvation Army and Russia at tab 84, Church of Scientology and Russia, which is tab 85, and Zhechev, ZCHEVEV, and Bulgaria, which is at tab 86. Well, the only trade union case which is material is one that my learned friend mentioned in her submissions but didn't take you to. And that's the case of Syndicatal Pastoral Cell Bun and Romania. In that case, I would like to take your lordships to. It's in the same volume of authorities at tab 93. And this is the case that my learned friend referred to by reference to the Employment Appeal Tribunal's citation of it, and I won't cover that ground again. Lords, I draw attention to paragraph 50. Your lordships will recall this was the priests who wanted to register a trade union. I draw attention to paragraph 57 on page 2933, where the court, in reviewing international law, sets out excerpts from International Labour Organization recommendation number 198. I don't invite your lordships to read that now, but it's a lengthy citation. Lords, then I take your lordships to paragraph 140, where the court deals with the question of whether Article 11 is applicable, and reading from the second sentence, they say, on this point, the Grand Chamber doesn't share the government's view that members of the clergy must be excluded from the protection afforded by Article 11 of the Convention on the ground that they perform their duties under the authority of the bishop and hence outside the scope of the domestic rules of labour law, which in our respectful submission is somewhat analogous to our own situation. But the material passages are at 142, which my learned friend read because it was the passage cited by the EAT. But I just call attention there to the reference to recommendation 198 and the reference back to paragraph 57 of the Grand Chamber's own judgment. And your lordships have seen that paragraph, or at least some of it, before. But I do take your lordships to paragraphs 143, where the court says, court observes that the duties performed by the members of the trade union in question entail many of the characteristic features of an employment relationship. For example, they discharge their activities on the basis of a decision by the bishop appointing them, setting out their rights and obligations, Under the bishop's leadership and supervision, they carry out the tasks assigned to them, besides performing liturgical rites and maintaining contact with parishioners. These include teaching and management of parish assets. Members of the clergy are also responsible for the sale of liturgical items. In addition, domestic law provides for a specific number of posts for members of the clergy and laity, which are largely funded from the state and local authority budgets. Post holders' wages being set with reference to the salaries of Ministry of Education employees. Romanian Orthodox Church pays employers' contribution on the wages paid to its clergy. Priests pay income tax, contribute to the National Social Security Scheme, entitled to all the welfare benefits available to ordinary employees, such as health insurance, pension, and unemployment insurance. So the Grand Chamber is setting out there the characteristics of these priests which point to an employment relationship, and your lordships will observe that they weren't paid by the person in the position of the employer, the bishopric, the bishop. And then in 144, they set out the other side of the scales. A particular feature of the work of the clergy pursues a spiritual purpose carried out in a church enjoying a certain degree of autonomy. Members of the clergy assume obligations of a special nature, bound by a heightened duty of loyalty, self-based on a personal and in principle irrevocable undertaking by each clergyman. May therefore be a delicate task to make a precise distinction between the strictly religious activities of members of the clergy and their activities of a more financial nature. And finally, at 145, the Chamber comes to its conclusion. Question to be determined is rather whether such special features are sufficient to remove the relationship between members of the clergy and their church from the ambit of Article 11. In this connection, the Court reiterates that Article 11.1 presents trade union freedom as one form or a special aspect of freedom of association, and that Para 2 doesn't exclude any occupational group from the scope of that article. That most national authorities are entitled to impose lawful restrictions on certain of their employers in accordance with Article 11.2. Moreover, other occupational groups such as the police or the civil service, likewise subject to particular constraints, special duties of loyalty without their members' right to organise being called into question. So, Lords, the test for an employment relationship, which I don't embellish my learned French submissions in any way, is really weighing up the factors pointing to an employment relationship by reference to ILO recommendation 198 and looking at the factors which point the other way. Lords, ILO recommendation 198 is in the bundle of authorities. It's in the first volume.
I don't mind going there at all. Is there more in it, though, than in the passage that's quoted in this authority?
Not really, my lord, but it's just, and I won't take your lordships to it. It's worth a look, though, if subsequently.
I wasn't stopping you. I was just thinking it would be more convenient to look into this authority as we have it open. But entirely up to you, Lord Underhill.
Well, my lord, all I was going to draw attention to in the words itself is that the recommendation makes clear that it's simply setting out indicia. That's all it's doing. A wide range of indicia, some of which are were relevant in that case, some of which are relevant in our case, some of which have got no relevance at all, some of which point in the opposite direction. So it's a weighing operation.
And yes, in the Good Shepherd case, I mean, it all went well for the Union in the passages you've read, and then they come crashing down in 161 and 162, and the courts say that the loyalty owed by priests to the Archbishop is the end of it.
Absolutely, my lord, absolutely. And I of course that's right, but then it is a two-stage convention right. And the question I'm addressing at the beginning is whether there was a violation of Article 11.1.
Can I just take this clear. No, I was just remembering how they argued this. They lost at the justification stage.
They lost at the justification stage, my lord. Yes.
Necessary in a democratic society.
Yes. Wasn't necessary, and it was thought that the setting up a union would be disruptive, I can put it that way, of the church's activities and so on. So, my lords, with those authorities in mind, I was going to take your lordships to some of the provisions of the legislation on trade union rights to demonstrate, I hope, that the exclusion of the NUPFC from being a trade union under the Act is not a restriction without meaning or significance. It is significant, and therefore it does amount to a violation of Article 11. So, Lords, I was going to divide this into two halves. One,
Can you just help me on something maybe unfair, Lord Hendy, because we get steeped in Article 8 in an immigration context, and you probably don't, so I'm sure you're pretty familiar with it. The Article 8 case law, we commonly talk about engagement of Article 8 and then justification. But engagement is usually used as a blanket term to cover the first two Razgar steps, as they're called. One, effectively, when the field of protected rights at all, and secondly, whether those rights have been interfered with. The terminology that seems to be used, certainly by all the parties here and in an Article 11 context, is slightly different. Engagement is used, as it were, at the very first stage, rather like whether it's within the ambit, which is another phrase in the Article 14 context, and interference is separate from engagement. That's not, as I say, the way it's used in an Article 8 context. I don't think that matters very much, but I just wanted to get it clear in my own mind what you mean by engagement.
well, my lords,
Engagement is separate from interference, I think.
well, my lords, we have difficulty with the notion of engagement at all. It seems to us that you're either protected by Article 11, and then the question arises whether Article 11 has been violated or not.
Well, no, the question is whether it's been interfered with.
Or interfered. I'm sorry, that's a much better
And
word.
violated covers whether it's unjustified.
Absolutely,
Yeah.
absolutely. And then after that, one goes to Article 11.2 to see whether the interference is justified.
Yeah.
But the Employment Appeal Tribunal here put engagement as a sort of prior stage. But I suppose it's legitimate to say, well, is this the sort of situation which would be covered by Article 11? If no more than that is meant by engagement, then perhaps it's a relevant inquiry. Because I suppose you could say, well, so-and-so has been denied a fair trial. Is Article 11 engaged? Answer, no. We're talking about Article 6, if anything at all.
Yes.
So Article 11 is engaged. We don't need to consider Article 11 any further.
Yes, I really wasn't wanting, that's been very helpful, I wasn't wanting to start a largely theoretical debate about what's engagement. I just wanted to flag up that it is used in slightly different senses. It's not actually a word that's used in the convention at all.
No.
And as long as we're all clear what we mean by at any particular time, that's all that matters.
Absolutely.
Okay,
Absolutely.
thank you, that's been helpful.
I'm grateful, my lord. So the question I would like to address now is whether there's been an interference of Article 11 rights, both for the union and for its members, and I was going to divide it up by looking at the rights of members first and then the union. But let me say at the outset, and it's a point that was hinted at by my learned friend Mr. Cooper in his intervention earlier, for many of these trade union rights, not all, but for many, there's a double blockage for NUPFC members. Because in order to rely on them, they've got to show that the NUPF is a union, and they also have to show that they are either an employee or a worker. And of course, Mr. Cooper says, well, there you are, simply allowing the NUPFC to be a union doesn't solve the problem where you've got a double blockage. But we say that can't be right. We can't get out of the starting blocks in asserting a trade union right as members until we overcome the obstacle of not being, our union overcomes the obstacle of not being a trade union. And of course, to pick up a point made by my learned friend Miss Krasnow earlier, who showed your lordships the case of Glasgow City Council and Johnston, we know that there are some, at least, of foster carers who may overcome the second hurdle of demonstrating that they are employees or indeed workers, but cannot overcome the first hurdle if they were to join the NUPFC.
We didn't look at the facts, or at least if we did, I didn't take them in the Glasgow case. Is this because the Scottish fostering system is different, or is it that just some local Glasgow in that case chose, or maybe didn't choose, maybe by accident, entered into a contract which was there?
It's the latter, my lord. It looks as if they entered into a contract without realising that that was not a good thing for them to do. And at the end of the judgment, there's a plea by their counsel to say we really didn't want this to happen.
Well, but that's what put me in.
Not a way out.
Yep. Thank you.
But of course, there may be other situations where foster carers are directly employed, by, for example, by agencies. We haven't. The field has not been surveyed. But at least for my purposes, it's a theoretical possibility that there are foster carers who are employees who overcome the second hurdle. So, my lord, with that in mind, can I take your lordships to the statute, which we don't need to spend a lot of time on, but it's perhaps helpful to see the provisions. For this, we need, first of all, section 137, which is either at page 128 or at page 244, depending on which version your lordships have. So, my lord, this is refusal of employment on grounds related to union membership, and it provides that it's unlawful to refuse a person employment because he is or is not a member of a trade union, or because he's unwilling to accept a requirement to take steps to become or cease to become a member of a trade union, or make payments or deductions in the event of not being a member of a trade union. And there your lordship see the two hurdles. This case relates to employment, and we know from its, your lordships needn't go there, I don't think it's been reproduced, but it's section 143.1 says that employment means under a contract of employment. So only foster carers who are employed can avail themselves of this right. But what's important is that they cannot claim this right, even if they're employed, if the refusal of work is on the grounds that they're a member of an entity which is not a trade union. So if they were refused work because they were a member of the NUPFC, they would not be able to claim this protection. And protections like this, as we've seen from Danielenko, are fundamental to Article 11. The same point, Lord, may be made in relation to Section 145A, inducements to trade union membership. This, it depends not on employment, but worker status is sufficient under Section 2961B, or Section 146, which of course was the foundation of the complaint in Wilson and Palmer, although the wording of Section 146 was subsequently amended to reflect the judgment of the Grand Chamber in Wilson and Parliament. That's the right not to be subjected to detriment if the sole purpose was to prevent or deter the worker from being or seeking to become a member of an independent trade union. And here there's yet a further problem for members of the NUPFC, because the union, it not only has to be a trade union, but it's got to be an independent one as well. And the same point can be made in relation to Section 152, which is a couple of pages further on, dismissal of employee on grounds related to trade union membership or activity. So all the protections against anti-union discrimination, which are an important part of the Act and a fundamental part of Article 11, are denied to a trade union, to a body which is not a trade union under Section 1 of the Act. Well, my lords, there are other provisions here which I don't think I need to take time off. Time off. Section 168, 168A, 169, time off for carrying out trade union duties, trade union learning, and so on. All those are denied to a body which is not a trade union. Section 170, time off for trade union activities. And Lord, the Employment Appeal Tribunal considered that those, some of those, I'm sorry, let me start again. So, my Lord, those are rights of a trade union member as against the putative employer. There are also rights which a trade union member has vis-à-vis the trade union, and these can be shortly stated as well if one goes back to the beginning of the statute in Section 10, which is at paragraph 4, page 46 in one volume, or 162 in the other pagination. Quasi-corporate status of trade unions. Trade union is not a body corporate, but it is capable of making contracts and being suing and being sued in its own name. Now, obviously, that's a right enjoyed by trade unions, but it's also of benefit to members as well, because they can contract with the union. The contract of membership is with their union, and then there are rights which they have as against the union. Section 15, there's a prohibition on the use of trade union funds to indemnify unlawful conduct, which union members have used in the past. At section 16, there are remedies against trustees for unlawful use of union property. There are other minor rights like 17 and 18, payments out of union funds on death and so on, which we needn't take time over. At section 27, which is at page 82 or page 198, depending on your pagination. Section 27 imposes a duty on unions to supply rules to the members. 28, union has to keep accounting records. 29, those records have to be available for inspection by members. 32 is the requirement of an annual return to the certification officer, and 32 requires that the union makes a statement to members following the annual return. Section 46 imposes a duty on trade unions to hold elections for certain positions, the National Executive Committee, President, General Secretary and so forth. Section 47 enables or precludes any member of a trade union being unreasonably excluded for standing as a candidate. 50 gives an entitlement to vote in elections to every member of a trade union.
Some of these benefits could be obtained and enjoyed by the present claimant. Some can't. Ones which are, for example, quasi-corporate status, the ability to enter contracts can't be concluded by just an unincorporated association, but it can by virtue of the statute. The right to hold elections and provide information to members can be provided by the association.
Yes.
But some of these are genuine differentiators between an unincorporated association that's not listed and one that is listed.
Yes, with the difference, my lord, that the ones that are optional for an unincorporated association are mandatory if it's a trade union. And that might be one of the attractions of joining a trade union rather than an unincorporated association. If you know that the unincorporated association can refuse to give you access, well, the point is obvious, my lord.
Yeah. And how far do you need to go with it? These are all advantages or rights which have been conferred by Parliament on a particular status.
Yes.
Difficult to say that they're not material or significant if Parliament has considered them and decided that they are important to confer by statute.
Absolutely, my lord. And the absence of them may be important for the union as well, although the Employment Appeal Tribunal seemed to consider that that would only enhance the attraction for the union, but it may be a discouragement of people to join the union if they know that they don't have the statutory rights that they would have if they joined, for example, the GMB,
so it goes to the
where they
economic
would have
viability
those
of the
rights.
union. It may go to the economic viability of the union.
Yes. Now, my lord, and just to finish, there's section 51. There's specific provision for the counting of votes by an independent person and scrutineers and so forth. Section 62 is the right to a ballot before industrial action. 64 is the right not to be unjustifiably disciplined. There are some things that a union can't discipline you for, but an unincorporated association might be able to. And then 226 and 227. 226 is at 170, requirement of a ballot before action by a trade union. There are long and complex provisions which some of your lordships are very familiar with. before a trade union can organise industrial action. So, but also, those are the rights of members, all of which depend on the entity being a trade union. For trade unions, there are a series of rights as well, and I can deal with these equally quickly. The first that I want...
More quickly, I hope.
Sorry,
I was being... it took quite a long time to go through all those. When you said equally quickly, I was saying
I'm
more
losing
quickly.
track of time, so...
Up to you, of course, how you spend your time, but...
So, my Lord, the first of the trade union rights I wanted to draw attention to is one that Ms Krasnow touched on, which is section 11 of the Act, which is page 47 or page 163, exclusion of common law rules as to restraint of trade. Says the purposes of a trade union are not by reason only that restraint of trade unlawful so as to make any member of the union liable to criminal proceedings for conspiracy or otherwise, or to make any agreement or trust void or voidable. No rule of a trade union is unlawful or unenforceable by reason only that it's in restraint of trade. Now, this is an antique provision deriving from the 1871 Trade Union Act. But, my Lord, it is nevertheless highly material. One appreciates, of course, that competition law has moved on with Article 101 of the treaty from the common law notion of restraint of trade. But this is still material. And the reason that it's material is demonstrated in a case called Boddington, which is at tab 26 of this same volume of authorities, which is page 615. Boddington and Lawton was a case decided in 1994, and it involved the Prison Officers Association. And what had happened there was that there'd been industrial action, and the question arose, the trustees raised the question as to whether the action could be funded, because in a prior case, it had been established that prison officers couldn't form a trade union. And the reason they couldn't form a trade union is because they have the powers of constables, and persons with the powers of constables don't rank as workers under the 1992 Act. So the question was whether there was protection against restraint of trade. Well, no need to read all the judgment of the Vice-Chancellor in that case, but picking up at 618 at the foot, one can see the reference to the earlier case in the beginning of the previous year, just 2 months earlier, Home Office and Evans. The association didn't have the legal protection of section 219 of the Trade Union Act because a trade dispute is between workers and their employers, but a prison officer is not a worker. Prison officer is not a worker because statutes give him like status to that of a person in police service, and a person in police service is not a worker. See the relevant sections. And the long and the short of it was that it was, as a consequence of that, it was considered that the Prison Officers Association itself was not a trade union and therefore didn't have the protection of Section 11. Your Lordships will note there that at letter F on 619, the Criminal Justice and Public Order Bill was then before Parliament, and in fact what happened was that it was necessary for Parliament to intervene to change the definition of worker so that prison officers could form a trade union and could form a trade union. question of restraint of trade is dealt with at 620, particularly at letter H through to 621 through to letter C. Lords, I'm not sure that your lordships need much more of this, but the fact of the matter is that because a trade union seeks, by definition under Section 1, to regulate the relations between workers and employers, in particular by collective bargaining with a view to collective agreements to establish the minimum terms on which the workers, the relevant workers, will work, that is a restraint of trade in itself. Whether it's a breach of competition law, Lord Justice Green will know much better than I, and in any event, even if it is, it's probably justifiable under the Competition Act. But that's not the issue here. The issue is whether it would be a restraint of trade such as to render the union no longer able to enforce the contract of membership. And this case shows that that is a real danger. Now, the importance of this here is that for this disbenefit of not having the advantage of Section 11, there's no second hurdle here. It doesn't matter whether the members are workers or employees or not. The organisation itself will be deprived of this protection. The Employment Appeal Tribunal considered this, and they held at paragraph 98, which is at page 110 of the judgment, that this possibility was remote in the extreme. Well, my lords, I'm happy to accept that it's unlikely, and if the National Union of Professional Foster Carers doesn't increase its membership beyond the 6 that we know that it already has, probably nobody will ever bother to look at issues of restraint of trade in relation to it. But it doesn't mean that the right to be protected is a valueless right which should not be protected by Article 11. And my lords, the other provisions relevant to a trade union we perhaps don't need to look at in detail, but the right to organise industrial action, the relevant sections are Section 20, which imposes a cap on damages, Section 219, which gives the protection to a union acting in contemplation or furtherance of a trade dispute against the inducement of breach of contract and conspiracy, and Section 220, which gives protection in contemplation or furtherance of trade dispute for picketing, and Section 244, which defines the nature of a trade dispute. Now, Lords, of course I accept, as Mr. Cooper intervened to say earlier this afternoon, that industrial action is barred to those who are not in a worker relationship in accordance with Section 296. But whether they should be denied the right to strike, they cannot get over the primary hurdle that those rights are only conferred on trade unions. Unincorporated associations cannot take the benefit of the protection given by going through the statutory balloting and notice requirements of the Act. And we know from Wilson and Palmer that the right to take collective action is an important aspect of Article 11. And my Lord, learned friends for the Certification Office and the Secretary of State say, well, industrial action for foster carers is inconceivable. It just can't be done. And of course I accept the reality of the situation, that they, like other occupational groups, wouldn't dream of withdrawing their labour if that meant that their children were put at risk, or their care was interrupted in any other way. But of course there are other steps that can be taken that might not interfere with that. For example, picketing of the local authority office in pursuit of a trade dispute, which wouldn't interfere with their home life at all. So, my Lord, that's an important provision. Sections 181 and 188 are also important. Those are the provisions which require or place a duty on employers to provide information for collective bargaining, and section 188 is the one that requires employers who are contemplating collective redundancies of more than 30 people to engage with unions and have some constructive dialogue as to the way in which redundancies may be avoided or mitigated. I should just say, in relation to information for collective bargaining, I think reference was made earlier to a collective agreement, and that which is defined by section 179, which is in your bundle. Section 179 is, no, it's not in the bundle, I'm sorry. Section 179 is the definition of a collective agreement, but its premise is, and I'll bring a copy for your lordships tomorrow, but its premise is that it's an agreement between a union or unions, trade union or trade unions, and employer and employers. So the NUPFC couldn't enter into a collective agreement at law, even though, of course, lordships know that such a collective agreement is not normally enforceable. So
well, to be accurate, they could enter into a collective agreement. It was simply not. Surely the effect of section 179 is to say the collective agreement, even if it might otherwise be binding, is not binding unless certain.
Yes.
Well, so section 179, but you can enter into a collective agreement any time you like, and it can't be worse off by section 179.
No, I'm not suggesting that there's any detriment in that, Lord, but the fact is that it's not a collective agreement within the meaning of section.
Okay, but that's not a matter of great
for what that's
unless it's. No.
Lord,
if you still want to bring it, can I ask you to send it electronically rather than bring it?
Of course.
We're being careful about handing documents about it.
Absolutely, Lord.
Yeah.
Well, the final area is, of course, collective bargaining. Section 70 of the Act and Schedule A1. Lord, Schedule A1 is only accessible if the entity is a trade union. Lord, it's at page 37 in the new printout, 153 of the old printout. Oh, I'm sorry, I've got
Other way around.
reference. I've got the wrong reference, forgive me.
Well, those of us who haven't updated their bundles have got Schedule A1 at page 36. Those who have, I can't help, so I'm not one.
Yes, I've got the old references, but not the new. Just give me one moment, Lord, I'll find it. It's page 220, or begins at 220, and paragraph 1 of Schedule A1, which is the collective bargaining machinery, is at page 221 or page 37. And your lordship see that paragraph 1 says that a trade union seeking recognition to be entitled to collective bargaining may make a request in accordance with this part, and paragraph 6, which my learned friend looked at this morning, was that the request is not valid unless the union has a certificate of independence. So you can't even start the process unless you're a trade union. Now, as to Schedule 1, there are two cases, of course, which my lords, Lord Justice Underhill and Lord Justice Bean, are only too familiar with, the Boots case and the Vining case, but I would like to refer to them briefly, if I may. Lord, they are in Volume 2 of the Authorities. Boots is at tab 51. Oh no, Volume 3, sorry. Boots is at tab 51, 1632.
Tab 51.
No,
if it is.
If it is 51,
I got it
it's
wrong.
this-
I was right first time. It's Volume 2, Penultimate Authority. And your lordships will recall that in this case, an independent union applied to be a recognised union and was barred because paragraph 35 of the schedule said that you can't apply if there's already in existence a voluntary collective agreement with another union. But in that case, because that other union was not independent, there was a means by which derecognition could be sought. And for that reason, this was not a breach of Article 11. And the material passages in my Lord Justice Underhill's judgment are paragraph 38, which I don't read, but where my Lord discussed the decision in Demir. Paragraph 45, where my Lord discussed the effect of the judgment in Unite and the United Kingdom and identified three elements. Paragraph 47, where my Lord said that in my view, therefore, the reasoning in the Unite case acknowledges the possibility that the absence or inadequacy of a statutory mechanism for compulsory collective bargaining might, in particular circumstances, give rise to a breach of Article 11. Such a reading is consistent with the logic of the reasoning in Demir itself, as discussed at paragraph 38 above. Fair to say that various observations by the court, and indeed the outcome of the case, tend to suggest that complaints based on the denial of a right to compel an employer to engage in collective bargaining may face an uphill struggle. But the point at this stage is simply that the attempt is not excluded in limine. And then paragraph 54, where my Lord discussed the scope of Article 11. Conclusions are largely determined by what I've already said about the effect of the Strasbourg authorities. Follows from the recognition by the court in Demir that the right to bargain collectively with the employer is an essential element of the rights protected by Article 11, that a complaint that domestic law doesn't accord with such a right in a particular case will fall within the scope of Article 11, but at the risk of spelling out the obvious, doesn't follow from that Article 11 confers a universal right on any trade union to be recognised in all circumstances. Self-evident that any right to be recognised conferred by domestic law will have to be defined by rules which identify which union should be recognised by which employers in respect of which workers and for what purposes. To the extent that the rules of any such scheme constrain access to collective bargaining for a particular union or its members, the constraints will have to be justified by, to use the language of the Unite decision, relevant and sufficient reasons, and should strike a fair balance between the competing interests at stake. But the decision also makes clear that in assessing any such justification, states should be accorded a wide margin of appreciation. And finally, at 60 2, the Lord said, like Sir Brian Keefe, who was the judge at the first instance, I would reach that conclusion on ordinary domestic principles of construction, but also like him, if it were necessary, I'd invoke the special principles applicable under Section 3 of the Human Rights Act, since if derecognition under Part 6 were not available, there would, in my view, be a breach of Article 11. Sir Brian, in fact, records at paragraph 21 of his judgment that before him, Hendy accepted that paragraph 34 could, with assistance, be read so as to avoid the alleged compatibility, not his position before us. I've read too much. Lord, that's the Boots case. Your Lordships will recall that of paragraph 62, the Employment Appeal Tribunal took the view that my Lord's judgment was obiter. That's at paragraph 93 of the Employment Appeal Tribunal judgment. But the Employment Appeal Tribunal's dealing with this case in our submission simply failed to grasp our point, which was that complete exclusion from access to Schedule 1 because we are not a trade union and cannot be a certified independent trade union because of the CO's decision, is the basis on which we can say that the inadequate, that Article 11 has not been adequately complied with. Lord, the second case and the final one to which I'm going to draw attention in my submissions is at 54, which I'm afraid is in the next volume, which is London Borough of Wandsworth and Vining, at page 1710, tab 54. Facts in the case there were that Parks Police were made redundant by the London Borough of Wandsworth, and amongst other things, they claimed that the Section 188 duty to consult with their union over those impending redundancies had not been complied with. And the argument against was, well, Parks Police are excluded from from Section 296, to which the claimant said, well, we rely on Article 11, we've been deprived of the right to collective bargaining. And the Court of Appeal judgment at paragraph 64, which is at page 1710, reads, if, accordingly, the rights in question fall within the scope of Article 11, the United Kingdom is under a positive obligation to secure the effective enjoyment of those rights. That doesn't mean that it's under an obligation to ensure that they're available to all employees in all circumstances. But it does mean that where a legislative scheme is in place, it must strike a fair balance between the competing interests and any provision of that scheme which restricts its availability to particular classes of workers requires to be justified, albeit that the state is recognised to have a wide margin of appreciation. Relevant principles set out by Lord Justice Underhill in Boots on the basis of Demir and Unite. Now, in that case, the Secretary of State had not advanced any justification for the exclusion of the Parks Police, and therefore there was a breach of Article 11. Before I put that case away, your Lordships will see that the court considered the reading down of the statutory provisions, and they deal with this at paragraph 73. Relevant statutory provision was section 280. I just read the first sentence. Real problem here is the distinction between those employees who should be caught by Section 280 and those who should not, in order to avoid a breach of Article 11, needs to correspond to the existence of a justification for that exclusion. Secretary of State offered no justification, and so on. And the court found it difficult to formulate a draft, and at paragraph 74, the court says, however, we don't believe that our inability to formulate a draft amendment to Section 280, which definitively distinguishes between the classes of employees whose exclusion is or is not justified, is fatal. As the authorities from Guidarn onwards make clear, it's not necessary, even though it's often useful, for a court to commit itself to such a formulation. In our view, it would be sufficient for us to say that, when construed in accordance with Section 3 of the Human Rights Act, Section 280 of the Act doesn't apply to the class with which we are here concerned. That's to say, persons employed as constables by virtue of Article 18 of the various legislative provisions. So that's how they dealt with reading down in that case. So, Lords, on the basis of all that material, we say that collective bargaining, our exclusion from collective bargaining machinery, is a significant detriment to the union. We hear the point that's made against us, that hours and holidays are not fixed and it will be inappropriate to do so for foster carers. But to that we say, but what about specification of minimum holidays or minimum pay? Statute.
Lord Henry, I just see the time. If
I'm so sorry, my Lord.
No,
yes.
no, if this is your, as it were, your peroration, let's have it. But if we're starting on a new point, we might be better to have it tomorrow. See where a natural break would be. Finish your point about hours and holidays, certainly.
Yes. Yeah. I'll do that, my Lord. So we say minimum hours and minimum pay are something that could be collectively bargained for. To say nothing of other matters beyond the three statutory matters, because like training or car allowances or short-term carers allowances, which are referred to in the Secretary of State's skeleton at paragraph 21, or fostering allowances, which he refers to in paragraph 22. And on holidays, Lord, we noted this morning that the national minimum standards to which Ms. Krasnow referred at tab 18 of the authorities bundle, page 534, no need to go there, paragraph 21(4), says that foster carers are entitled to minimum breaks. Well, there's something that could be negotiated.
That's holidays, not rest breaks.
Sorry, Lord?
That's holidays, not rest breaks.
Yes.
Yes.
Yeah. So, my Lords, it's on the basis of that material we challenge the Employment Appeal Tribunal's conclusion that the CO's decision amounted to a quote, no material interference with the NUPFC Article 11 rights. That's paragraph 100, or paragraph 126, where they said it was a fairly minimal intrusion, or paragraph 125, a relatively limited restriction. Well, we say all these, they may not be, we say that these are significant restrictions.
Is that a good point to start?
That is a good point, Lord.
I'm afraid forgotten what the roadmap was that given by Ms. Krasnow. How much longer are you expecting to be?
Between half an hour and 1 hour, I should think.
So and that's within the allowed time, is it?
It is, my lord.
Very well. We'll meet again at 10:30.
Yeah.